Welcome back, everybody, to our studies in land law. We are now on to topic number 8 of this godforsaken subject, and we're moving on to the subject of easements. Easements are particularly interesting. They have certain interesting elements to them. It won't be a particularly long topic in reality, and this is actually the third to last topic we're going to be covering, at least for free content. There are some members-only subject topics that we will do as well, but for the most part, we're going to do easements, we're going to do freehold covenants, and then we're going to do mortgages. And then when we look at members-only content, we're looking at, I believe, leasehold covenants and adverse possession, and I think one other topic as well. But for now, topic number 8, this is the subject of easements. So this topic is going to, or at least this video specifically, is going to examine what an easement is, what are the requirements for an easement, especially for the creation of an easement when it comes to law. So two questions we're really going to be asking is, what is an easement, number one, and then number two, how are easements created in law? In answering number one, it is quite simple. An easement is simply a right over a piece of land for the benefit of another piece of land. So, essentially and simply put, if I have some land that I have some interest in land that I wish to benefit from, but in order for me to benefit in this land or to have the full and total enjoyment of the piece of land that I own, I must have an interest in a different piece of land that is known as an easement. Okay, so in order for one to benefit from a piece of land, they must have some right in another piece of land over another piece of land in order to actually get access to that right. Then we have an easement. And a good example of this is a right of way. If you have some piece of land, but in order to actually get to that piece of land, you have to be able to travel through a different piece of land, then you have a right of way. And this is a proprietary interest. This is an easement that is a proprietary right in rem over that other piece of property. Fundamentally, if the key requirements for an easement are present, it will have the ability of having proprietary status as per Section 1, Subsection 2 of the 1925 Law of Property Act. So it has quite significant advantages. It has significant legal rights and legal interests. Now, in order to find the key requirements for an easement, we don't actually look to the statutes, we don't look to the legislation, we look to the common law. We look to the case of Re Ellenborough Park. This is one of the most important cases in land law, so make sure you understand it. And fundamentally, we will go through it and think about what the requirements for easements are as a result of this case. Now, this case specifically involved a house which was near Ellenborough Park. Now, it had been granted the right to use the park as part of a leisure garden up until World War II. At which point, the government had taken over and taken control over the entirety of the property. If this was determined to be an easement, and as a result of which it would be determined that they had a legal right, then this would mean that the government would have to pay compensation for the deprivation of said legal right. If it was not an easement and therefore only a right in personam, then there would not be this same kind of compensation requirement. The courts held that, in order to make a determination as to the existence of an easement, there must be 4 requirements, and if, in this instance, an example, these 4 requirements are met, then an easement does exist. The requirements are as follows. Firstly, there must be the existence of what is known as a dominant and a servient tenement. Secondly, there must be accommodation of the dominant tenement. Thirdly, there must be a distinction between the dominant and servient tenements. And fourthly, finally, there must be a right which must lie in a grant. These are the 4 requirements that are outlined by the case of Re Ellenborough Park in relation to the creation of an easement. Let's then unpack each of these different elements and these different requirements. So what do we mean when we talk about dominant and servient tenements? What actually does this actually mean? And bear in mind that we're going to come on to this kind of language as well when we look at freehold covenants. So don't think that you can just forget about it as soon as we've finished our lessons on easements. So bear that in mind. Simply put, the dominant tenement will be the land that is able to benefit from the right, and the servient tenement is the land that is burdened by the exercise of the right. So let's say, for example, I have a house, and in order to get to the front door of my house, to get to the property, there is another piece of land, and therefore there has to be a right of way over that piece of land. The piece of land to which there is a right of way is the servient tenement, because it is burdened by the existence of the right. My right of way over and into my property is burdening the servient tenement. It is burdening that piece of land. And as a result, the land that I own, the house, is the dominant tenement. It is the part of piece of property that is benefiting from the right of the servient tenement. That's simply how it works. When an easement is acquired, there must be a clear identification of both a servient tenement and a dominant tenement. There has to be two pieces of property. One is servient, one is dominant. The next requirement, an accommodation of the dominant tenement. What does this mean? Well, accommodation in this regard simply refers to the improvement of the land which is subject of the dominant tenement. So there must be an improvement of the land as a result of this. It means the meaning of accommodation in this regards, therefore, refers to the enjoyment of the right in connection with the normal use of the land, okay? So there is an accommodation of the dominant tenement as a result of the enjoyment of that right in connection with an ordinary use of that land. This will be a question of fact, and it is one that will require an account of evidence, simply put. In addition to this, there has to be a distinction of ownership between the dominant tenement and the servient tenement. This is as established in the case of Rowe and Siddons from 1880. It makes it clear that you cannot enjoy an easement over your own land. So if we go back to the example of a house that I own with a right-of-way requirement over a different piece of land, if I just owned that other piece of land as well, then there wouldn't be any need for an easement, okay? There has to be a dominant tenement and a servient tenement, and they have to be distinctly owned by different people or by different organizations. This defeats the purpose of an easement if I just owned all of it, because the idea here is that I own a piece of land and I have to burden a different piece of land in order for me to have an ordinary enjoyment of that property. If I just own it all, then there is no need for an easement at all. So there must be a diversity of ownership. The final requirement is that the form has to be in the form of a subject matter of a grant. This is justified on the basis that an easement is a right which has the ability to exist at law. And so owing to the fact that it has to have the ability to exist at law, it must be capable of being granted by way of a deed. And so the final requirement, therefore, means that the granting of an easement will firstly require a grantor as well as a grantee, a person who grants and a person who, therefore, receives a grant. And it also must be capable of being defined. This has actually given rise to there being multiple different categories of easements. And these categories are as follows. We have easements of way, so for example a right of way, which is what I've been talking about in this lesson as an example. You have what are known as easements of support, easements of light and air, easements that relate to the rights of artificial waterways. There are of course other categories, but these are the most common. And when I think about and I carry on doing the different examples, for the most part I'm going to be referring to easements of way, like rights of way, but we will look at cases that relate to other types of easements as well. It's just that it's easiest to understand easements in relation to rights of way because they're basic and they're quite intuitive to understand. Welcome back everybody to our studies in land law. In the previous lesson, what we did was spend some time talking about the concept of the easement. We focused a lot of our time specifically on what an easement fundamentally is and how it is defined in the case law, specifically and pertinently within the case of Rhea Ellenborough Park. This lesson is going to spend some time talking about the acquisition of an easement. Now, we're not going to examine all of the modes and methods of acquisition in this lesson because we will get to some of the other ones in future lessons' time. But fundamentally, what we're going to do is spend a little bit of time talking about the concept of easement acquisition, and then secondly, focus on the first type of easement acquisition, which is known as express acquisition. So as I've just mentioned, the previous lesson looked what an easement was, and then talked about what is required for the creation of an easement, citing the leading authority in this area, which is the case of Re Ellenborough Park. This lesson is now going to turn to looking at the process of determining the acquisition of easements within the law. So easement acquisition is something that can be achieved through one of three main methods. The first is the one that we're going to spend some time focusing on in this lesson specifically, talking about the concept of an express acquisition of an easement. The second is known as implied acquisition of an easement and involves something that we'll talk about in a future lesson's time. And then finally, we'll spend a couple of lessons, in fact, talking about the concept of prescription of an easement, something that is a little bit complicated and has some complex elements to it. It's not too bad in the overall, but it has some elements that might be a little bit tricky for some people to get their head around. So we'll spend some time looking at that finally, and then we will get to looking at the termination of an easement and some other elements that can be spoken about with regard to easements. We also have this final one that is sort of attached to the end when we talk about acquisition of easements, which is the fact that some easements can be granted by way of statute. And the reason why I'm not going to spend that much time, if any time really at all, talking about the acquisition of an easement through statute is mainly just because it's relatively straightforward. It's not particularly difficult to understand the process by which a statute can grant easements. So let's begin first then. Express acquisition. This is the simplest process by which an easement can be granted, other than, of course, through statute. Of the three that we have spoken about, that we're speaking about, should I say, this will be the simplest of those three. And essentially what is required is that a document exists which grants or reserves the right for a party to have an easement, potentially within a particular transaction or through the acquisition of property deeds and all these different kinds of things. And that's simply it. That's simply the beginning and ending of how an acquisition can take place from an easement. But what it says here as well is two things. It says here that a document may exist which grants or reserves the right for a party to have an easement. So it's not just talking about the granting of an easement in law, but we're also thinking about this idea of a reservation of an easement. What does this mean? What do we mean when we talk about granting? Well, the granting of the right, fundamentally. But what about the reserving of the right for a party to have an easement? Well, express reservation occurs when the vendor of a property decides to sell part of their land, but they want to reserve an easement over that land that has been sold. So it is not really the acquisition of an easement by way of it being granted to you, as in if there's some document which exists which gives you property rights or whatever, which then also, as part of the existence of that property right, may also give you right to access through a way of an easement. But it's different. It's a sense of if you have a property and you want to sell part of your land, but you want to ensure that you still have certain amounts of rights, maybe for access, for example, over that land, then you might decide to, in the process of selling this property, opt to reserve an easement over the land that has been sold. And what this means is you will be selling the land, you will be selling and conveyancing that property, you'll be selling the fee simple, but you may still wish to remain and retain a certain right that is held over that land by sale of the easement. Now, this is something that can be done expressly, and so we see this done through the sale of property per se. So if there is an agreement that is put in place on the sale of a property, you will have various different terms in that agreement, including, for example, and not limited to, things relating to the price of that property, the point of sale, and all these different kinds of things. If it's a mortgage that's being set up, you obviously have to do deals and have conversations with the bank that you are setting up your mortgage with. But then there might also be terms relating to this particular element here. The idea that we want to have a term that is expressly stated within the agreement that we reserve the right to have an easement over the property for which we can actually enjoy some enjoyment of maybe our property, for example. And generally speaking, it's something that is unlikely to be implied through the courts. And so as a result of which, the concept of the easement reservation is one which is almost entirely, or at least mostly, done and mostly occurs through the express acquisition of property or the express reservation of an easement. So, as a result of this, and sort of to conclude this broader conversation, where there is a sale or transfer of either a leasehold or maybe even a freehold estate, the deed must include an express reservation for an easement on the part of the vendor, if that vendor obviously chooses to wish to have and maintain a certain amount of rights of access or whatever the particular easement is for over their property, over that property specifically. So if there is the desire on the part of the vendor to actually have an easement, they must make that very clear in the deeds for an express reservation. Welcome back, everybody, to our studies in land law. The previous lesson we talked about the express granting of an easement, the expressed acquisition of an easement more specifically. And we talked about how this could be done through either grant or reservation, specifically talking about the process by which a vendor may be inclined to, upon the conveyance of their property, they may be inclined to essentially withhold access to potential areas of their property or potential rights over that property by way of an easement, and this is sometimes known as an expressed reservation. We also noted in the previous lesson that there were three main ways by which an easement is acquired. Well, technically four if we include statute, but we're not going to be talking about statute very much, given that it's very, very simple. A law is passed that gives grant to an easement, simply put. The three main ways in which an easement is acquired in the law is through expressed acquisition, implied acquisition, and this process known as prescription. This lesson is going to focus on the second of these ways of managing an easement and acquiring an easement, namely through the implied grant of an easement. The previous lesson, as I mentioned, was a relatively straightforward process, the process of express acquisition of an easement in land law. This lesson shall look at the implied grant of an easement in land law, a topic which has a little bit more complexity attached to it. Hence, the length of this lesson is slightly more so than that of the previous one. So, an implied grant of an easement, as the name suggests, is a situation where there is no expressed contingent in place for the acquisition, the granting, or the reservation of an easement, but rather the courts have been able to, for a particular reason, imply that an easement has been granted, either through necessity, either through the concept of common intention, or through the rule in Wealden and Burroughs, the case from 1879, and or finally under the provision of Section 62 of the Law of Property Act. So if there is a situation which arises in which the courts feel that it is pertinent to imply the granting of an easement either through one of these four methods, then an easement will have existed and have been acquired by this implied grant. Let's begin then with the first of these processes, the concept of necessity in the applying or the implying of the granting of an easement. Well, essentially, an easement can be implied through a court over a piece of land if it is determined that in order for the use of that land to actually be able to be done, it is necessary for there to exist an easement. This is fundamentally what the process of necessity requires. That if it is implied, essentially, if we look at a piece of property, we look at some land, and we think, well, you cannot enjoy or use this land in order without the grant of an easement. It is necessary for the enjoyment of that land and the use of that land. So the courts have set a relatively high bar, a relatively high standard for what is required in relation to the concept of necessity here. It is more than just the desirable element of the land. It is more than just, oh, I would enjoy this land more if there was an easement. It has to be the case that it is necessary for the use of the land. So, for example, if the land in question was locked off without the existence of some right of way, then it must be necessarily the case that an easement is implied, if it isn't expressly stated in the grant already, over another piece of land that essentially gives you access to your land. That's more than just the mere desirability of the property. That is essentially strikes at the heart of being able to even use that property in the first place. Hence why that would be considered an implied granting of an easement by way of necessity. The case of Minjiang versus Dramar from 1990, for example, held that an easement may not necessarily be implied under this method, under the method of, for example, locking some property out and blocking a right of way, if there is another route to the property. And this is the case even if this other route is less convenient. And that goes back to the second point that I have cited on this slide here, the sense that it must be more than just merely desirable and a merely desirable element on the property. It has to be more than that in order for it to actually be a necessity for there to be a grant of easement. If there's another way of getting to that property, even if it is less convenient, if it is a bit more cumbersome, this would still not satisfy the necessity requirement for the implied grant of an easement. Easements implied by necessity are not implied for convenience or desire, but like I said here, they are implied for the necessity of the use of that property. Secondly then, common intention, the second of the major elements that we would refer to here. Well, an easement may be implied through this idea of common intention if it is necessary for the use of the land for a specific purpose for which there is a common intention among the parties, among all the parties to this particular property. If there is a common intention among all of them about what this property ought to be used for, then this common intention requirement would essentially imply the granting of an easement. As one would argue, something of a variation of an easement which is implied through necessity, there is still a certain element of necessity required in this common intention requirement, but more specifically we're talking about the common intention by the parties. The previous implication is done on the basis that any use of the land must require an easement. This is done on the basis that the intended specific use of the land requires an easement. So, whereas the implying of an easement through necessity required there to be an easement for any use of the land at all, and I used the example of some property that essentially is blocked off by some other property, such that there is no way of even getting to the property without going over or going across that property. But this is slightly different. This isn't necessarily talking about any use of the land at all. It is suggesting that there may be an agreed upon, a collective agreement on what this land is going to be used for, but that in order to even use that land for the property that is going to be used for, there is a necessity of having some kind of easement. That's what that requirement essentially relates to. And I want to draw your attention to the 1965 case of Wong and Beaumont Property Trust Limited. This was a case in which a landlord had leased his property to the tenant for the purposes of running a restaurant. So there is a specific purpose for this property. It is the property of a restaurant business. In order to run the restaurant, the tenants would have to comply with a myriad of different health and safety standards, of course, one of which would require the fixing of the various different ventilation systems on the property to ensure that they were up to the standard of health and safety at the time. Now, an easement was therefore impliedly granted in the lease in order for the tenant to fix the ventilation system. Notice here that what this does is illustrate the view that when the landlord leases this property to the tenant, there is the common intention. There is a mutual intention on the part of the landlord and the tenant to have this property leased for the purposes of setting up a restaurant. And this is a very specific purpose. And in order to set up a restaurant, you must therefore comply with health and safety standards. And in order to comply with health and safety standards, there must be the fixing of the ventilation systems on the property. And so if there wasn't this common intention, if the landlord had simply leased the property for living in that property potentially, then it might have been the case that there would not have been the necessity for the easement of the fixing of the ventilation system, because the fixing of the ventilation system had to be done in order to comply with health and safety standards for a restaurant business. And so as a result of all of this, it is suggested here that it is necessary for the running of and for the use of the land in the way that it has been agreed upon that that land is going to be used, that there was an easement in place in the lease, implied in the lease by the courts, for the fixing of the ventilation systems. The third way in which a lease, an easement can be implied into a lease, into a property at all, really, not just a lease, is through the case of Wealden and Burrows from 1879. This case establishes a separate rule for the creation of an easement, which may be implied by a grant of something known as a quasi-easement. The case itself involved a dispute between a claimant and a defendant who had both been sold land by a third party. This third party we'll just call A. To the claimant, some of the land was sold, and to the defendant a month later, a workshop which was adjacent to the land was sold. Now, the claimant would build a board which would ultimately lead to the blocking of light entering into the workshop of the defendant, at which point the defendant would, quite rudely in my opinion, knock it down, claiming that it had access, that they had access to light by way of an easement. Now, I'm not sure if there was a conversation prior to this about whether or not they could take the board down amicably, but all that we know is that the defendant knocked the board down. If you want to read the facts of the case, you can go and do so. But they argued on the basis of this that there was access to light that was implied through their easement. And it was argued that when the seller of the property sold the land to the claimant, he had impliedly reserved the easement access of light. There's access to light easement. The courts actually disagreed with that, and they found for the claimant, and they concluded that the defendant did not in fact have access to the light by way of an easement. But what this did was establish a rule. The rule has the effect of taking a quasi-easement. So this is a right which is for the benefit of your own land, and then elevating that to a full easement. And the courts concluded in this case that there were three conditions that are required for the creation of this type of easement. The quasi-easement must be firstly continuous and apparent. Secondly, it must be necessary for the enjoyment of the property for which it was sold. And then thirdly, it must have been enjoyed by the vendor before the sale of the property, when they were the owner of both the dominant and the servient tenements, the dominant and servient properties. If you have those three conditions, then you may have the possibility of implying the granting of an easement through the Wealden and Burrows case and the Wealden and Burrows rule. Finally then, let's get to section 62 of the Law of Property Act, the final way in which we can imply an easement through the courts. Essentially what this does is allow for the passing of all rights which exist over a land, including the easements, to a successor without the need for this to be an expressed implication in a conveyance. So essentially, if you buy a property and own a property and you have an easement on that property and there's no controversy about how this easement was acquired, it was maybe even that was expressed in the deeds, and you go about enjoying the property and then you go on to sell that property. Well, to suggest here is what we are thinking about is that section 62 is essentially saying that you can then pass all of the rights which existed over the land that you enjoyed, and this includes easements, and this can be done without there being an express note in some kind of conveyance agreement saying that there is an easement, okay? And I would just like to finally finish this lesson by talking about the case of Wright and Macadam from 1949. This was a case which involved a landlord who was the defendant, who had had let a top floor flat to the claimant. In this agreement, they gave the claimant access to their garden, specifically their garden shed, for some storage purposes. An additional room was then granted to the claimant in a new tenancy for her and her daughter to live. Changing circumstances, now they wanted to essentially create a new tenancy agreement in which she would get an additional room. This new document, however, made no reference to the enjoyment of the shed for storage purposes. So it was an easement that she had enjoyed as expressly stated in the first tenancy agreement, but there was no such reference to it in the second tenancy agreement. This might have been just something of an oversight as to everything that is included in both agreements. When the defendant then attempted to extract payment for the use of the shed, the claimant argued that their new tenancy agreement included a right to use the shed, just as the previous tenancy agreement had as well. This went to court, and the court indeed found for the claimant, and they held that in accordance with Section 2 of the 62, of the Law of Property Act from 1925, there is the ability for the license for storage to be converted into an easement granted impliedly over that property.